Losing your job is always stressful, but it's even worse when you feel like it wasn't fair. Many American workers wonder, was I wrongfully terminated? The term gets used a lot, but legally, it has a very specific meaning. Here's the surprising fact. Because the U.S. follows the at-will employment rule, most terminations, even ones that feel unfair, are technically legal. Your boss can fire you for almost any reason, or no reason at all. But there are exceptions. If you were fired for an illegal reason, like discrimination, retaliation, or exercising a legal right, that's when it becomes wrongful termination. In this video, I'll break it down. What wrongful termination really means under the law, the common illegal reasons for firing, how federal and state laws protect you, and what steps you can take if you think you've been wrongfully let go. Part 1. At-will employment and the narrow definition of wrongful termination. To understand wrongful termination, you first have to understand the concept of at-will employment. In the United States, the default rule in almost every state is that employment is at will. That means either the employer or the employee can end the relationship at any time, for any reason, or for no reason at all, so long as the reason is not illegal. This often surprises people. If your boss fires you because they don't like your attitude, or because business is slow, or even because they want to hire their nephew, that's usually legal. Unfair? Absolutely. But wrongful termination under the law is narrower. It only applies when the firing violates a specific law, contract, or public policy. So, what are those exceptions? First, discrimination. Federal laws like Title VII of the Civil Rights Act, the Age Discrimination in Employment Act, ADEA, and the Americans with Disabilities Act, ADA, prohibit firing someone because of their race, color, religion, sex, national origin, age, over 40, or disability. If your termination was motivated by one of these factors, that's wrongful. Second, retaliation. It's illegal for an employer to fire you because you asserted your rights, like filing a discrimination complaint, reporting harassment, requesting overtime pay, or blowing the whistle on unsafe practices. Retaliatory firings are one of the most common forms of wrongful termination. Third, violating employment contracts. If you have a written contract, a union agreement, or even an implied contract promising job security or specific procedures before termination, your employer must honor those terms. Firing you in violation of a contract can be wrongful. Finally, many states recognize a public policy exception. This means your boss can't fire you for reasons that violate fundamental public policies, like refusing to break the law, serving on a jury, or taking legally protected medical leave. The takeaway is this: most firings in America are legal under at-will rules. But if your termination involved discrimination, retaliation, breach of contract, or violation of public policy, it may qualify as wrongful termination under the law. Part 2. Wrongful termination based on discrimination. One of the clearest forms of wrongful termination is when an employer fires someone because of who they are, their race, gender, religion, disability, or other protected characteristic. Federal law has strict protections here, and most states add even more. The cornerstone is Title VII of the Civil Rights Act of 1964. It prohibits employers from firing or taking any negative action against workers based on race, color, religion, sex, or national origin. Over time, courts have clarified that sex also includes pregnancy, sexual orientation, and gender identity. So, if an employee is let go because they're pregnant or because of their sexual orientation, that's wrongful termination under Title VII. Age is another protected category. Under the Age Discrimination in Employment Act, ADA, employers cannot fire workers who are 40 or older just because of their age. If a company lays off older employees while keeping younger, less experienced staff, and age is the real reason, that's illegal. Then there's disability. The Americans with Disabilities Act, ADA, prohibits firing someone due to a physical or mental disability as long as they can perform the essential functions of the job with or without reasonable accommodation. For example, if an employee with diabetes needs short breaks to check their blood sugar, firing them for requesting that accommodation would be wrongful termination. Religion is another area where protections apply. Employers must make reasonable accommodations for employees' religious practices unless it causes undue hardship. If someone is fired for taking time off to observe a religious holiday, that could be illegal. Many states expand these protections. Some include marital status, sexual orientation, where not already covered federally, or even political affiliation. States like California and New York have especially broad anti-discrimination laws covering more categories than federal law. It's also worth noting that discrimination doesn't always look obvious. Employers may try to hide it behind neutral-sounding reasons, like downsizing or poor performance. But if evidence shows the real motivation was bias, such as comments about age, sexist remarks, or a pattern of firing only one demographic group, courts can find discrimination. For workers, the process usually involves filing a charge with the Equal Employment Opportunity Commission, EEOC, or a state human rights agency before suing. The EECC investigates and can help resolve the case. So, when termination is tied to race, gender, religion, disability, or another protected characteristic, it isn't just unfair, it's unlawful. That's when the label wrongful termination truly applies. Part 3. Wrongful termination based on retaliation. Another major category of wrongful termination is retaliation. This happens when an employer fires an employee not because of performance or business needs, but because the worker exercised a legal right or reported wrongdoing. Federal law makes retaliation illegal in many contexts. For example, under Title VII, an employer cannot fire you for filing a discrimination complaint, participating in an investigation, or even supporting a co-worker's complaint. The Fair Labor Standards Act, FLSA, protects workers from retaliation if they complain about unpaid wages or overtime violations. The Occupational Safety and Health Act, OSHA, prohibits employers from punishing workers who report unsafe working conditions. Here are some real-world scenarios. A waitress reports sexual harassment by a manager. 2 weeks later, she's fired for poor attitude. If the real reason was her complaint, that's retaliation and wrongful termination. A warehouse employee contacts OSHA after seeing repeated safety violations. When management learns about it, they suddenly cut his hours to 0. That's retaliation, and it's illegal. An accountant refuses to falsify financial records. Days later, she's terminated for being uncooperative. That firing violates public policy and counts as wrongful termination. Retaliation is one of the most common claims filed with the Equal Employment Opportunity Commission, EEOC. In fact, EECC data shows that more than half of all discrimination-related charges include a retaliation claim. That's because workers who speak up often face backlash. The law is designed to prevent this chilling effect. If employees were too afraid of losing their jobs, they'd never report harassment, discrimination, wage theft, or safety issues. That's why retaliation protections are so strong. It's also important to note that retaliation doesn't always mean immediate firing. Employers might demote an employee, cut their hours, reassign them to worse shifts, or create a hostile environment to push them out. Courts and agencies look at the overall context. If the action would deter a reasonable person from exercising their rights, it can count as retaliation. For workers, proving retaliation often comes down to timing and evidence. If you file a complaint and are fired shortly after, That timing raises red flags. Documentation, like emails, performance reviews, or witness statements, can strengthen the case. So, if you lose your job after standing up for your rights or reporting misconduct, that's not just unfair. It may be classic wrongful termination through retaliation. Part 4. Wrongful termination through contract violations and public policy exceptions. Not all jobs in the U.S. are strictly at will. Sometimes employment relationships are governed by contracts or collective bargaining agreements. When an employer ignores those agreements, a termination can become wrongful. For example, if you have a written employment contract that promises job security for a certain period, say 2 years, and your boss fires you after 6 months without cause, that's a clear breach of contract. Even without a written contract, some states recognize implied contracts created by handbooks, policies, or verbal assurances. If your company's handbook says employees will only be fired for just cause, and then you're let go without reason, you may have a wrongful termination claim. Union contracts negotiated through collective bargaining also protect workers. These agreements often include just cause provisions, meaning an employer must have a legitimate reason and follow specific procedures before firing an employee. Terminations in violation of these rules can be challenged through the union grievance process or arbitration. Then there's the public policy exception to at-will employment. Even in states that strongly follow at-will rules, courts generally agree that employers cannot fire workers for reasons that violate public policy. This includes refusing to break the law. If your boss orders you to commit fraud and you refuse, firing you for that refusal is illegal. Performing a legal obligation. If you're fired for serving on a jury or for military service, that violates public policy. And exercising a legal right, for example, taking leave under the Family and Medical Leave Act (FMLA), or filing for workers' compensation after an injury, reporting illegal activity. Many states have whistleblower protections that prevent employers from firing workers who report violations of law. Real-world example: a nurse who reports patient safety violations to state regulators cannot legally be fired for that reason, because protecting patient health is a matter of public policy. Similarly, an employee who files a workers' compensation claim after getting hurt on the job cannot be lawfully terminated in retaliation. The public policy exception ensures that at-will employment doesn't give employers unlimited power. It draws a line. You can be fired for many reasons, but not for reasons that undermine fundamental legal and ethical principles. So, while wrongful termination claims based on contracts or public policy may be less common than discrimination or retaliation, they're just as important. They remind both workers and employers that at will does not mean anything goes. Part 5. How to recognize wrongful termination and what steps to take. If you've just lost your job, it can feel confusing and overwhelming. Was it just an at-will firing, or was it actually wrongful termination? The first step is learning how to recognize the warning signs. Look closely at the reason given for your termination. If your employer's explanation doesn't add up, or if it changed over time, that can be a red flag. For example, if you consistently had positive performance reviews, but were suddenly fired after filing a harassment complaint, the timing suggests retaliation. Next, think about whether you fall into a protected category. Were you treated differently because of your age, gender, race, religion, disability, or pregnancy? Did your termination follow soon after requesting medical leave, reporting unsafe conditions, or asking for unpaid overtime you were owed? These connections can indicate wrongful termination. Documentation is critical. Save emails, performance reviews, text messages, and witness statements. If you were denied breaks or asked to falsify records before being fired, keep proof. Write down dates and details while they're fresh in your mind. If you suspect discrimination or retaliation, the usual next step is filing a charge with the Equal Employment Opportunity Commission, EEOC, or your state's human rights agency. These agencies investigate claims, and you generally must go through this process before filing a lawsuit. For contract or public policy violations, you may have other legal remedies. Unionized workers should use the grievance process. Non-union workers may consult an employment attorney to explore filing in court. Many states allow workers to recover not just back pay, but also damages for emotional distress and, in some cases, punitive damages against the employer. Importantly, the law protects you from retaliation after termination claims. If you file a complaint, your employer cannot blacklist you, threaten you, or interfere with future job opportunities. If they do, that adds another legal claim to your case. Finally, don't ignore the value of legal advice. Employment laws vary by state, and an attorney can help you evaluate the strength of your claim, navigate deadlines, and potentially negotiate a settlement. Many offer free consultations or work on contingency, meaning you pay nothing unless you win. The bottom line, not every firing is wrongful termination, but if your job loss was tied to discrimination, retaliation, breach of contract, or a violation of public policy, you may have powerful legal protections. And with the right steps, you can hold your employer accountable. So, what really counts as wrongful termination? In the U.S., because of at-will employment, most firings are legal, even when they feel unfair. But if you're let go for an illegal reason, like discrimination, retaliation, breach of contract, or violating public policy, that's when it crosses the line into wrongful termination. If this happens to you, remember, you're not powerless. Document everything. Know your rights under laws like Title VII, the ADA, the ADEA, and the FMLA. And don't be afraid to file a complaint with the EEOC, the Department of Labor, or your state agency. Many workers have successfully fought back, recovering lost wages and even additional damages. If this video helped clear things up, hit like, share it with someone who might need it, and subscribe for more plain English explanations of workplace law. And let me know in the comments, have you ever seen someone fired for a reason that felt truly unfair?